Hi, Bill Henshaw here again for the Constitutional Crisis Channel. Another hot topic with current events that we're experiencing all over the place, particularly in California, are evictions and foreclosures. The eviction part we're going to pay serious attention to today because it's my opinion, and I have already sent letters out to certain local sheriffs here. I'm going to be sending some more out, and to the president of the Sheriff's Association to let them know that their deputies and any other peace officers don't have any authority to execute evictions pursuant to Section 1161 of the Code of Civil Procedure here in California. And they don't, because if California is not a state, and I can prove that, I may not be entirely sure what it is, but I know it's not a state admitted into this union. They don't have any judicial courts. Therefore, when they attempt to go in there, whoever it is, and sue you and get your ass out of there, without judicial courts, there can't be judicial process, yet the Constitution prohibits the legislature from enacting bills of attainder, which is the taking of property without judicial process. Here, among other things, that would be your unlimited power to contract pursuant to Article 1, Section 10 of the Constitution of the United States, and Article 1, Section 8, I believe, of the California Constitution 1849, still in full force and effect. So if the sheriffs are without authority to forcibly evict you, that changes the legal landscape dramatically. And it gets worse because, in my view, the agents, particularly if, in the case I'm dealing with now, they're not licensed to do business with the California Secretary of State, and even if they were, it doesn't help because that's the territorial Secretary of State, and my friends are domiciled in the state of California, then they have no standing to go into a court and attempt to do anything. Even the so-called owners of the property may have some serious problems here because they have at best, in my view, an equitable interest. They're acting as trustees for the territory of California who owns title to all the real property here, and or the Bureau of Land Management in Washington, D.C. That's a subject matter for another video. Nevertheless, it looked like to me, if you wanted to get somebody in a common law court, if we could find one that had status and standing, it's going to have to be the territory of California, and they ain't coming. Because if they admit they're a territory, all hell breaks loose, and you're going to let the cat out of the bag, which may in this case be something along the lines of a tiger who's going to turn right around and bite you. They can't do it, and they won't do it. These are the kinds of issues that I'm working on right now. And I've got to tell you up front, at the moment, there isn't a quick fix. But as soon as we get one or two of these decisions settled and decided by courts of appeal and higher courts, now you have legal precedent on your side. And the sheriffs are going to stay home when they're asked to go out and do evictions because they know damn well they can't do it. So you can check in with me if you want to check it with my email with ccaspari@live.com here right in front of me. You know, I'm ready, willing, and able to help, at least in certain cases, and provide you with documents and others that I can't get personally involved in, and for a very reasonable service fee, to say the least. And we can help fight these people, and even if you're already out, it doesn't matter, because if the proceedings were fraudulent from the beginning, those are what's called void judgments. Not voidable, two different things. Void from day one. And everybody that was in on that judgment, including the plaintiff, the judge, the sheriff, whoever, they knew or should have known it was void. They have taken oaths of office to preserve, protect, and defend this Constitution, and they're supposed to know that. More interesting stuff later on a follow-up video. Thank you.